Hello, I'm Andy Agapangelo, the founder of the Transparency Task Force. The Transparency Task Force, or TTF, is a certified social enterprise based in the UK, but we reach out to approximately 4,500 people around the world in 21 countries. And every one of those countries has some kind of a financial services sector, and every one of those countries has some kind of experience in relation to whistleblowing. In some parts of the world, the role of whistleblowers are understood, respected, and protected. I'm thinking here, for example, of the United States, where there, believe it or not, is even financial incentives for people to blow the whistle. It seems like the US is a long way ahead of the UK in terms of its understanding of the true value of whistleblowers. Without a doubt, ladies and gentlemen, whistleblowers perform a remarkably important social service. They help bring the truth to the surface, and sometimes what they're able to reveal is of enormous value. Enormous value. So, isn't it a terrible shame when sometimes whistleblowers aren't listened to? I'm thinking, for example, of one of the experiences of our main speaker tonight, Paul Carlier. And there he was working with some financial experts in London, by coincidence, in the next door room to a bunch of people, phoning up elderly, vulnerable individuals and persuading them, conning them, defrauding them into moving money into Blackmore Bond. So what did Paul do? He did the right thing. He did the obvious thing. He contacted the FCA and told them all about it, only for the FCA to do nothing with it. Isn't it a terrible shame when whistleblowers aren't listened to? A few years ago, I had reason to research the common themes within some tragic events. I was particularly interested, for reasons I won't go into right now, as to what led to things like the Hatfield rail disaster, the Zeebrugge ferry disaster, the Moorgate crash, the tube crash. And one of the things that connected all of these horrible tragedies was that in every case, somebody within those organizations alerted the senior people, the authorities, to say, if this happens, this might happen and people might die. There was one chap, for example, was involved with the Zeebrugge ferry disaster. He basically said, if we rush the process of closing or of loading the cars on, and we're slack in terms of closing the bow door, and the tide's coming from a certain direction, the wind's coming from a certain direction, the boat might start taking on water. And if it does, it'll carry on taking on water, and hundreds of people lost their lives. It's truly tragic when people who are trying to alert senior managers or the authorities to things going wrong aren't listened to. But it's even more tragic, ladies and gentlemen, when the authorities who ought to do all they possibly can to protect those who are brave enough and motivated enough to speak out. And when they have a duty to do them, yet they still don't, then that takes us into even more worrying territory. And when an authority actually deliberately sets up an email intercept and divert process that, amongst other things and other types of stakeholders, hurts whistleblowers and complainants, that's even worse. So here we are in 2023 talking about whistleblowing in the context that the whistleblowing framework in the UK clearly is not working. And we want to challenge the status quo. And we want to challenge the status quo in the way that we do, and the way that I think we do pretty well. We want to challenge it with evidence and insight and experience and knowledge, and with nothing other than good intent in our hearts when we do it. Now, the timing of today's event is peculiar because it's one day after a Times article that Paul Carley will be speaking about, a topic he knows incredibly well, this issue of intercept and divert by the FCA. Yes, the FCA, the country's primary financial conduct regulator, the entity that should frankly be a shining example about how to do things right as far as GDPR is concerned. The article, as Paul will explain, actually reveals that the FCA has not been playing by the rules. So one day after that article and a few days before the Transparency Task Force submits some thoughts about the whistleblowing issue to Kevin Hollingworth MP. And the reason why we're going to be sharing our thoughts with Kevin Hollingworth MP is because of the item I'm about to share with you on the screen. So this is a web page that I'll put a link to in the chat. It's all about the government's review on whistleblowing. And we, all of us, have an opportunity to feed in our thoughts to this. It's from the Department for Business and Trade, which is the department that Kevin Hollingworth now works with or for. And we know that Kevin's had an interest in this topic for some years. I'm just going to read out a comment he makes in the opening section here. So it says, Business Minister Kevin Hollingworth said, whistleblowing is a vital tool in tackling economic crime and unsafe working conditions. And the UK was one of the first countries in the world to develop a whistleblowing framework. The review has been a priority for me since joining government, and it will take stock of whether the whistleblowing framework is operating effectively and protects those who call out wrongdoing in the workplace. I'll put a link to that in the chat. I'm going to ask anybody that wants to help me with a very important task. As I mentioned just now, it's only a few days before we want to get our notes to Kevin Hollingworth. When he and I interacted by email on this, he said he wants our thoughts by the end of this week. I would very much appreciate people that volunteer to send me in the notes from today's event. What I'm hoping you might do, ladies and gentlemen, is just take notes about the key points that come up, send them to me by email. I'll absorb all that as best as I can and turn it into some coherent message that we can send to Kevin Hollingworth. That's the plan. All right. So if you're up for taking some notes, please do. They don't need to be wonderful English, just bullet points is fine. It's almost just an aid memoir to make sure I cover the important stuff that gets covered. There are all kinds of really important stakeholders in this whistleblowing space. For so many reasons, perhaps one of the most important are ethical reporters and journalists who operate in an investigative reporting way. Our first speaker is going to be Lindsay from Thomson Reuters. We know, as a matter of fact, within TTF, that Lindsay's remarkably good at her job and she has a real interest in this topic of whistleblowing. We got some phenomenal speakers tonight. Lindsay's our first. Can you please welcome Lindsay to the microphone? After Lindsay, who's going to be speaking for about 5, 6, 7 minutes or so, we'll be going to Paul Carlier. Lindsay, thank you very much. Please take yourself off mute and please dive into what you'd like to share about this ultra important topic of whistleblowing. Thank you, Lindsay. Thank you.
Hi, can everyone hear me? Okay.
We can perfectly well. Thank you.
Sorry, new laptop, not sure about the settings. No, thank you. Andy invited me to speak tonight about the reporting that I've been doing. I'm not a whistleblower, I'm not a campaigner, I'm a journalist, and I'm a pretty niche journalist at that. I cover financial regulation. So that's everything to do with complying with regulations, new regulations, the regulators, how they're held accountable, etc. And so sort of having set that scene, about 5.5 years ago now, I read an employment tribunal judgment. The case was Banerjee versus Royal Bank of Canada. And the reason it interested me was that Mr. Banerjee had basically suffered detriment. And I read the final judgment. So basically, it wasn't a matter of whether the tribunal had found that he had been treated adversely. In this case, he was dismissed, kind of forced out, after he made protected disclosures. Now, the thing that interested me is, as I said, I'm a financial regulation journalist. And so he had, made disclosures about really quite an alarming flaw in what was supposed to be a key piece of check and balance on the people who who trade, etc. And so I won't take up too much of your time, but basically, fundamentally, John had worked out that by being requested to do this annual attestation process, which is the way that the firms check that their staff know the rules and regulations that they're supposed to adhere by, and he had found that links in it were broken, and it turned out, in the course of the tribunal, that basically most people were just ticking this. Nobody had clicked on the documents they were supposed to read, so nobody else but him had reported the links were broken. This included the compliance staff at the bank, who also had to do it. Anyway, so that was the kind of issue, that piqued my interest in this. Was, here was somebody who was quite, not in an antagonistic way, but had raised this issue. He'd found this fault, he'd raised it, he thought it was concern, quite seriously, if people aren't being able to certify themselves each year, that they are familiar with the rules and, whatever, it's quite important. And then this had happened to him. And so that was the first case that I covered. And then I've covered various ones in the last 5.5 years. I'm just going to pick out a couple. So the next one I would highlight is a case involving Wells Fargo. Now, I'm not sure how many I'm speaking to an audience of whistleblowers, so maybe some of you do know. The whistleblowing test is kind of twofold at an employment tribunal. You first have to prove that you made so-called protected disclosures, and then you have to prove that you suffered detriment as a result of that. So in this case was interesting because while the court accepted that the individual had made numerous protected disclosures, he didn't prove that he'd suffered detriment, or he did so, although I believe the case is going to appeal. But in the course of this tribunal, two senior managers from Wells Fargo actually admitted further regulatory breaches. And so in relation to senior managers are supposed to be trained in UK whistleblowing, it's called CISC 18. It's called CISC 18. They're supposed to be trained in that. In the course of this, under oath, two managers admitted that they'd never been trained in whistleblowing, etc. And so I then flagged this to the regulator and said, surely you're going to look into this. And they said, at the time it turned out that they believed that, or they told me that it was only if a firm lost an employment, because I'd queried why supervisors weren't attending employment tribunals involving quite serious regulatory breaches were part of his disclosures. Queried why the regulator wasn't attending, and I was told at the time that firms only have to notify the regulator if they lose a tribunal. So it's very hard, as I'm sure others will tell you, to actually, the proportion of people who win at a tribunal is absolutely negligible. So that was, sorry, I should have said, in John's case, the other thing, there were various things in the tribunal, in the judgment, which concerned me. The judge had basically called the head of audit at the bank incompetent. So how this man could pass a fit and proper test. I mean, he basically said, here are like half a dozen other ways that I could have done an audit that, to have proved this, and you didn't do any of them. So what were you doing? And there were a couple of other senior people in there that got singled out by the judge. One of them was actually warned about perjury. All of these people, last time I checked, still in role. So I'd asked the FCA, what was it doing about these people? Fit and proper rules, but judge calls you incompetent, so, but again, anyway, so those are those two cases. Then fast forward a few years, actually till this year, earlier this year, my colleague Rachel Walcott and I, we were having a conversation with an ex-senior regulator, and they kind of said to us, yeah, I would have said that you, under Principle 11, firms have an obligation to notify the regulator of any employment tribunal dispute involving a whistleblower, where the whistleblower, allegations are about flaws, compliance flaws. And so we then went back to the FCA and challenged them on this. And lo and behold, actually, that is the point. So they've been kind of giving the wrong information for about 3 years. So that's something. This is about the regulator kind of not doing its job. And then Andy mentioned James's article yesterday, which obviously there are serious implications about the treatment of whistleblowers from that. I wrote about one today where so there was a Complaints Commissioner report that was published in August, and in it there's a line that says basically whistleblowers, an individual wasn't entitled to whistleblowing protections under PIDA because he'd given up his anonymity. Now, this is tosh. It's absolute tosh. It's not in PIDA. And I knew that the individual concerned had challenged the regulator on it, got nowhere. I knew that a whistleblowing organisation had written to them and also written to the Complaints Commissioner to say this is wrong. And then, so yesterday I'd kind of got all my ducks in a row on this and was about to report on it, but you go to the regulator to ask for comment. That's part of being a good journalist at really finding a story. So at about 3:15 yesterday, I emailed the regulator and said, this is wrong. Your interpretation of PIDA is just wrong. And also on a secondary point about the other part of the complaint had been about the whistleblower suffering victimization. Now, under something called CISC 18, which you can go and look it up, CISC 18.3.9, it actually says that if you cause detriment to a whistleblower, it's serious implications for an individual and serious implications for a firm. They could lose their license to operate in the UK, and individuals can be struck off ultimately from practicing in this country. That's never happened. And so I've asked the FCA about this many times before, and this was my second point yesterday. So my story was written, I was waiting for them. I actually didn't expect a response because so often with the FCA, I don't get a response. But anyway, I was waiting for a response for my deadline of 5 p.m. to pass. At 5:10, I got an email from the FCA saying, oh, yeah, we've made a mistake. And we're going to write to the whistleblower and apologize. Yeah, just a mistake. Of course, PIDA, that is not the correct interpretation of PIDA. So I checked with the whistleblower. About 15 minutes after I got my message, he got an apology. Anyway, I rewrote the story and it went out today. However, both last night and throughout the course of the day, I have been pursuing with the FCA the second point, which is every bit as important, about the victimization. What is it doing about victimization? And just for some context here, I know because of FOIs that I've put in, there are several hundred whistleblowers in the last 5 years who have contacted the FCA because they've already blown the whistle at their firm and suffered some form of detriment. The FCA has said to me that the vast majority, so it didn't subcategorize. There are various bits of CISC 18, didn't subcategorize them. But they said it was fair to assume that the vast majority of them were about people suffering detriment. And yet there's been not, as I said earlier, there's been not a single case of the FCA taking action against a firm for victimizing a whistleblower. Now, it's a few years since I've studied statistics, but to me that seems statistically anomalous anyway. And so, but I've heard absolutely nothing from the FCA on this. They're just not replying. And I just, before I go, because I said to Andy, I won't need 5 minutes, and I really appreciate I've talked for longer than that. Just one final point. The complaints commissioner, I went to her and said, this is a mistake in PIDA. Why haven't you, this is wrong. And then she said, well, that's what the FCA said. I'm only repeating what the FCA said. And if you think the FCA's got it wrong, then you need to take it up with the FCA. Two things on that. She said it wasn't so she said, and I have to assume she's right because she runs a scheme, that it wasn't part of the scheme for her to question the FCA's interpretation of PIDA. I am surprised by that. She's a lawyer. She's about to become chair of the board of the Law Society. She's registered with the SRA under SRA principles. All solicitors have an obligation to, point out things when they know, let alone somebody who's a complaints commissioner and sees something that's wrong. So, and she didn't respond to me on what about her SRA principal responsibilities at all. So I'll stop talking. But the main thing I'm trying to say is, over the last 5.5 years, what I think is I've been reporting on is an increasingly messy situation, despite numerous revamps by the FCA. The outcomes for whistleblowers are not getting any better. The investigation of serious allegations, regulatory allegations, is just not happening, or it's not finding its way. The FCA always says, oh, well, we, in its report, we take action, the various forms of action, but there has been no enforcement, which is what most people would expect, especially when in some of the cases I've mentioned, there are legal findings of fact that the firm, so the FCA would be completely safe in pursuing individuals because there are legal findings of fact or the firms, there are legal findings of fact that that something has occurred. They don't even have to make that decision. A judge has already made it for them in the employment tribunal. Right, I'll stop talking, Andy, and that is me. Thank you for your time.
Lindsay, we're very, very grateful to you once again for speaking in such a forthright and technically accurate and precise way. I'm not just saying this to be nice, Lindsay, but you are remarkably good at the job that you do with Thomson Reuters, and there are many people within TGF who are big fans of you and the work that you do. And hearing you come tonight and talk about this very, very important topic just gives us even more reason to be very grateful to know you as we do. Ladies and gents, can I please invite you to do two things simultaneously? One is to thank Lindsay for what she just talked about, and also simultaneously invite Mr. Paul Carley to the mic. Paul's going to be talking for about half an hour. Please do tune into what Paul's saying. It's phenomenally important stuff. It really, really is. And I absolutely promise you, well, I'd bet my house on everything Paul's about to say to be absolutely 100% factually correct, unless he says something like, this bit's my opinion. This is an opinion bit, but this stuff over here is fact. He's one of the most credible speakers we ever have. Mr. Paul Carney, you're an absolute treasure for the cause. You really, really are. The mic's yours, Paul. Over to you. Thank you very much.
Thanks, Andy. One thing I'd just like to touch upon, you mentioned earlier a few examples of if whistleblowers have been listened to. If you look at the recent Russell Brand case, if you look at the Me Too case with Weinstein, if you look at the Jeremy Kyle show, you look at, and also probably the most distressing of all, the Grenfell Tower case, the inquiry there, somebody at the firm, the cladding firm, was aware that the cladding didn't meet the criteria, but was too scared to speak up. And unfortunately, this is the system. You're either too scared to speak up, or when you do speak up, then you are going to suffer detriment. So, just a little on that. So I'm going to try and get this into 30 minutes, Andy. I will whiz through some slides so that even if I don't get to cover it all, there's a documentary record that people can go back and view. So I'm going to share my screen now. Where are we? So can you see that?
And if you go to slideshow, there we go. Perfect.
Yeah.
Paul, thank you.
Play from the start. Right. Everyone see that? Is that okay?
Thank you.
Right. Okay. So this is the reality. Whistleblowing financial services. As Andy just said, everything. I never make an allegation unless I believe I'm right, and I never make an allegation or complaint unless I believe that I have the evidence to demonstrate or prove it. Unless, and I've forgotten, if it's just an opinion, I'll express it and explain why. Before I start, this is to the FCA, the Complaint Commissioner, and Charlie Nunn of Lloyd's. Just stop it. I mean, I'll explain more later, but how much more do I have to expose about your conduct, your breaches of law, your breaches of the rights afforded me by law, before you accept what you've done, apologise to me, and just deliver justice and remedy and put things right so that it doesn't happen again. And I'll explain more as to why as we go. So this is 17th of August this year. The Employment Tribunal accepted a brand new claim from me against Lloyds Bank. This is 8 years after my first tribunal hearing and 8 years after I left the bank. I've overcome time barring, and the reason I've been able to do that is because the new claim was only possible after I obtained a substantial cache of internal FCA documents, all dated 2015 and 2016, last June, all of which, or there was 200 plus of which, should have been disclosed to me by the FCA in 2017 in response to DSAR, but hadn't been. Now, and what they revealed was a whole host of issues enabling me to plead brand new issues that I hadn't been able to plead before, and it just exposed a staggering concealment and dishonesty by the FCA that effectively helped Lloyd's deliver a miscarriage of justice at my previous tribunal in 2015. I will come to it more on it a bit later. But importantly, on 13th of October, we have the case management hearing, and item 1.2 on that agenda is, should any person be joined or dismissed as a respondent? If yes, why? So the tribunal has allowed me the opportunity to apply to have the FCA and the PRA added as second and third respondents. It would be a groundbreaking decision if I can get this done, but I believe I've got the evidence to prove that, but for the actions of the FCA and PRA, I would never have been subject to the wrongful dismissal I had in the first place, and then secondly, having suffered the wrongful dismissal, but for the actions of the FCA and PRA, I would never have been deprived of whistleblower protected status by the tribunal at my original hearing. And by that, I mean, I won unfair dismissal and I won £76,500, which was the maximum at the time for unfair dismissal. But I was deprived of whistleblower status, which deprived me of the opportunity to plead that it was my disclosures result of were the cause of my dismissal, and for up to £7 million in compensation. 76,500 sounds a lot, but by the time I got that 76,500, almost 2 years had elapsed since I was dismissed, and during that time I would have earned for 450,000 at Lloyd's. So I won, but I lost a substantial amount. So if I can get this done, and I'm sure I've got the arguments to do it, this would be a groundbreaking employment tribunal. Now, this is what I'm going to introduce here. One of the reasons why I'm able to at least attempt to get them added. This document is dated 24th of October 2016. And as you can see, it's sent to, among others, Kenny MacArthur of Andrew Bailey's office. Now, Kenny MacArthur is one of several private secretaries that Andrew Bailey had. Better, in my opinion, I can better describe them as henchmen. I mean, there is no other word for it. Now, as you can see here, this is a summary here of the person is an expert in FCA supervision who in October 2016 was tasked with doing a complete new investigation of all of my disclosures that I had made and escalated to the FCA in 2015 with evidence to support it. And I want to draw your attention to this, that the reason they were doing it was because of my sense of injustice over the dishonesty and injustice over the way the disclosures were handled, particularly the attempt to defraud Tesco that took place on the 1st of July 2014, and that I spent 38 minutes in a battle with the salespeople at Lloyd's to prevent happening. And they, as you can see here, the reason they're doing it is because they are so concerned about my well-being and that I'm in significant distress. So page 2, so this is why they did it. And it was this report, this is the findings. On page 2, this here, where it says, in that instance, it appears that Tesco's order was only confirmed in full as a result of Mr. Carlier's remonstrations, and that had he not done so, Tesco would have been treated less favourably by, and the redacted part is the 2 salespeople of the sales desk. Now, this is incredibly important. To the benefit of LBG's proprietary book, i.e. the financial gain for the bank. This FCA expert corroborates entirely that Lloyd's salespeople had attempted to defraud Tesco's and that they would have got away with it but for my actions on that day. Now, I didn't get this document until several years later. And, you know, it was one of those, oh my God, smoking gun moments. But this was dated 24th of October 2016. But 2 months later, the FCA, because after my tribunal in October 15, I had made an allegation against the FCA that they had gone out of their way not to investigate my disclosures. They had failed to review the evidence and they had failed to protect me and therefore left me vulnerable to a miscarriage of justice on the whistleblower issues at the employment tribunal. Now, I made that complaint in October 15. The judgment came from the tribunal that was after my hearing. The judgment came in December 15, and sure enough, I won unfair dismissal, but I was deprived of protected whistleblower status. Now, in October 2016, they should have disclosed this to me. The FCA should have gone, Paul, we've done an investigation. We are really sorry. We dropped the ball in 2015 because this proves they didn't investigate in 2015. And I've got other evidence to prove that. They should have then taken action against Lloyd's. The 2 salespeople should have been sacked. Also, the Lloyd's group security and fraud investigator who claimed he'd investigated my disclosures, but then produced falsified findings, and I've got the evidence to prove that, he should have been sacked. Lloyd's should have been obviously taken to task for causing detriment to a whistleblower, but also they'd lied in legal proceedings. So Lloyd's would have had to have settled with me for a substantial sum. And the group security and fraud investigator that falsified the findings did so 6 months after doing the same to Sally Masterson, the ex-Boss Reading whistleblower. They used the same guy. Now, in November 18, Lloyd's had to apologise to Sally and settle with her for a substantial sum because and admit they'd lied all along. They'd lied about her report. They'd lied about her findings, and they had attacked and smeared her. But then 6 months after, so they knew they'd done it at the time, but 6 months later, they instruct the same guy, former Met police officer, to do the same to me, and he falsified his findings. So, but in December 2016, the FCA finally provided a response to my complaint that I'd made 14 months earlier. The conclusions in that complaint response entirely contradict the FCA experts one. They deny there was anything. Now, could I then prove that the complaint investigator had seen these findings by the FCA expert? Yes, because I've also now got a copy, only obtained last year, of the first draft of her complaint response. And in it, she refers to this investigation, refers to this report and this finding. Yet a month later, she takes it out, takes all reference to that out and replaces it with the conclusion that contradicts that finding. Who does that? That was her first draft was 13 months after she'd started investigating my complaint. So you've got to stand to reason that must be her position, having done that investigation. So did she voluntarily falsify that finding, or was she encouraged to do so by one of these people to whom it was sent, including Andrew Bailey's office? So that's going to be one of the issues for the employment tribunal to decide. And if they don't, then I will be taking it further. And it's also subject to a application for judicial review. Now, much has been made of James Hurley's article this week and about the complaint commissioner, Amandeep Samal. She's going to, she's so aggrieved and upset by what the FCA has now been exposed to having done. I mean, she gets on her moral high horse. Yet when I did a DSAR to the complaint commissioner, because when I got that report and that finding that you saw on the previous page, I go, okay, well, this proves the FCA complaint response of December 16 was entirely falsified and dishonest. How then did the Office of the Complaint Commissioner uphold that response in 2018? Did the FCA disclose this report to them? So I asked Amandeep Samal, please, can you confirm if you if the FCA disclosed a copy of an investigation report sometime between September and December 2016. I didn't want her to know that I had the document. I gave her enough so that she'd be able to find it in minutes. And I wanted to see if she would disclose it, if they had it. Well, she refused, saying it was burdensome. She then spent God knows how long writing a 4-page letter to my MP, Laura Trott, who had simply said to her, why don't you just confirm to Mr. Carley whether you've got it or not? So she said, oh, burdensome, time-consuming, everything else. And spent God knows how long producing a 4-page letter to that effect. So I just said, well, okay, there's a DSAR. Now you've got to give me everything. And she did. And in there was the copy of that report. However, this is from that report. She redacted the smoking gun paragraph. Now, everything in that paragraph that she's redacted, I'm going back to it here. It says here about Mr. Carlier's remonstration. It's got my name in it, so it's about me. It's also relevant to the forming of an opinion about me and or their forming of that data controller's intentions in respect to me. That's 3 criteria, any one of which means it's personal information that has to be disclosed. All 3 of them are in there, and yet Amardeep Samal and her colleague was forced to admit that they had redacted that. The FCA didn't redact it, they did. And she did it to conceal the smoking gun paragraph because it exposed her office of either acting dishonestly in 2018 or incompetently because they didn't, they literally didn't understand the significance of it. But the fact she redacted it means she absolutely knew this was a smoking gun paragraph, and she lied to me and concealed it. Another breach of GDPR. So when she gets on her high horse about the FCA's breach of GDPR, seriously, you've had all this evidence I've given you over the last 2 or 3 years, and you've just lied to me, you've concealed evidence from me, and only now, because the cat's out of the bag, are you getting off your high horse, getting on your high horse and doing something about it. Unbelievable. So this is one of the smoking gun documents I got last year, and why the FCA I'm going to be adding. Now, this is astonishing. This is an email that basically was sent by the whistleblower team. This is a week before my employment tribunal in 2015. The parts in red are the answers given to the FCA whistleblower team by, I believe it to be, the FCA General Counsel Department. So the FCA's lawyers are putting these positions in red to the whistleblower team. So look at the first one. Can we tell Mr. Carlier that he can ask the tribunal for the FCA to be called, or that the tribunal has the option of considering asking for the FCA to be called? They specifically prohibit the FCA whistleblower team from telling me this. Now, for 2 months before that, me and my MP had been asking the FCA to provide an opinion on the attempted fraud Tesco. Was it wrongdoing as I said, or was it not wrongdoing as Lloyd said? I wasn't asking for help. We were asking for an opinion, because if Lloyd's were saying it was and I was saying it was, how could the tribunal decide? Now, they knew I wanted an opinion and they were stalling and going to extraordinary lengths to prevent it. But they didn't disclose to me there was actually an established protocol for them to get involved in whistleblower cases. So in other words, if I made an application to the tribunal for the FCA, the prescribed person and experts to provide an opinion, then the FCA would be obliged to do so. They told the whistleblower team they absolutely prohibited him from telling me. Now, what they then did as well, number 6, right? They tell the whistleblower team, tell Mr. Carlier that supervision is still considering the issues he raised. Nonsense, this was a lie. Because I've now got documents that were dated November 2016, which show the status of the FCA's investigation into my disclosures. And it says the last action taken was receive the investigator's report from Lloyd's June the 2nd, case closed, same June 2nd. They literally got the report from the Lloyd's investigator, whose report I'd alleged was falsified, and just accepted it as gospel and closed it down. So when and this is what I was told, it was a lie. They told them to lie to me the week before my tribunal. Now, if you've seen that finding, you saw the finding, the FCA expert entirely corroborated my allegations. Had they done that and reviewed it in 2015, Lloyd's would have had to settle me for millions, because in the same way they did, because it proves that there was a detriment. It proves my disclosures were, exposed an attempt to defraud Tesco. So let's move forward to the story by James Hurley on Friday. Basically, for those that don't know, the ICO has just ruled that what they call an intercept and divert protocol that was established by Andrew Bailey's office in 2016, whereby the incoming emails of persons that are noisy or let's just say people of interest or concern, were being diverted away from their intended destination, including the whistleblower team and the complaints team, okay, to a central hub or email account monitored by Bailey and his minions. Okay, so where they could then have a look at it and then either keep it contained within themselves or send it on to where it wanted to go, but with some briefings as well as to how they would like it handled. So in other words, it was ring fencing everything, and so they got oversight of everything, which corrupts the independent functions of the complaint process and of the data team, because they were also intercepting DSARs. Okay, so you have an astonishing... Now, FISMA obliges the FCA to operate a complaint scheme. And as Andy mentioned before, this potential case here, that gives every individual in the UK the right to make a complaint to the FCA about the FCA. It's a statutory right. And here, this process breaches that. And I would also argue, and certainly given the evidence that I've got and the way that they have behaved with me, it also enables them to breach the Fraud Act, because there's a part of the Fraud Act, fraud by failing to disclose information you have a legal obligation to disclose. So, and I can prove that in 2016, October 2016, the 200 plus documents I didn't get that I now have, one of them is an internal note authored by the person that was who produced the dishonest complaint response in December 16. In it, she writes that she's now been tasked with processing my DSAR, and she's got hundreds of documents to review and print. And so she was put in a position which is quite clearly intended to censor that DSAR response so that it removed and withheld any document that to some more significant extent exposed the falsified finding that she put in that letter in December 16. So, I mean, it's astonishing that it's far more than just GDPR. There's fraud involved here. And in the article...
Can I just cut in there, Paul? Sorry. Folks, the piece that Paul has just referred to, it really is astonishing. It's absolutely astonishing. I'm going to put a link into the chat to a slide deck that elaborates on some of the detail in the Times piece that Paul has just referred to. And within the slide deck, as you'll see, we ask some pretty powerful questions. It's going to be remarkable to see how this unfolds. Paul, please do carry on. And thank you so much for what you've covered so far.
I urge everybody to download that slide deck, keep it safe, because you don't know, God knows how many people have been subject to this. But in the article, it refers to the fact that the first person subject to this in 2016, they claim they did it because this person was aggressive. Well, I've got every reason to believe that that was me. I was the first person subject to this. This is an email dated June 2020, and it was from the author's redacted, but it was to somebody who was investigating a complaint of mine. And again, specific to these various concerns and allegations I've made about the conduct previously. This person writes, I retrieved it from a segregated account that was set up because Mr. C was emailing various people across the organisation, and we were trying to limit their exposure because Mr. C's correspondence could be quite aggressive. Now, that's exactly how the Times article explains the first person that they did this to, because they were quite aggressive. And I know that I was subject to this protocol in 2016. So it stands to reason that it was likely me. Now, what concerns me here is that the author's name's been redacted. Now, the FCA has an agreement with the ICO that they will not redact the names of anybody at manager level or above, right? That's an agreement. So basically, the name on there, this is the recipient. I've got no beef with this guy. I don't know him from Adam, and I've never had any reason to doubt this guy or know what his involvement was. However, the author is a guy by the name of Kenny MacArthur, the same guy who was in Bailey's office, who was the recipient on that report that corroborated my findings. The reason I know this is because he says here, I'm pretty sure Mr. Carley stopped corresponding with me, and I insisted I didn't correspond with him. The reason that means it has to be MacArthur, because he's the only person in the FCA who I have ever said, don't ever correspond with me again. The guy lied to me. He created false narratives about me. It was astonishing. And yeah, Mr. MacArthur, if you're listening, by all means, if you've got a problem with that, you know where I am. I've got the evidence to back up what I'm saying. Now, this was sent to me in a DSAR in October 21. Now, why have they redacted MacArthur's name? he was a manager. So why was it redacted? That article reveals that prior to October 2021, the FCA knew they had a major problem with this issue. They knew it was a breach of GDPR, and they knew that this was going to have serious issues, as has now been established by the ICO. So did they redact MacArthur's name? Because this email, obviously it's quite specific. It reveals that I was subject to this protocol. Were they trying to conceal the fact that Bailey's office was involved? Don't know. But, you know, I can't think of another reason why they would have redacted his name. Right. This is something that I hope is going to be groundbreaking. This is an email. Andy will be aware of this. This is from the Metropolitan Police, who I've spent 7 months trying to present them with the evidence to prove breaches of the Suicide Act and breaches of the Fraud Act by employees of Lloyd's and employees of the FCA. As it's taken me for God knows how hard this has been. Now, they have now confirmed under this crime reference that they are now going to open a criminal investigation into this, right? So I'm going to be interviewed. It's going to be all probably recorded, and they are going to be then interviewing witnesses and everything else. Now, the reason I'm sharing this tonight is that any other whistleblower that has suffered a detriment where they can prove that they have suffered a detriment at the hands of their employer or the FCA, email Subrol on that email address that's on there, right? Like you say, look at the recent Russell Brand thing. The Met Police have had to say they've had more and more reports come in and they're going to investigate them all. Okay, I want more and more reports. Anyone who suffered a detriment, this is your chance. This is your chance to email the Met Police and add it to the case so we can establish just how significant, how prolific or how systemic these abuses are. Breaches of the Suicide Act, if you ever pushed to the brink or you were suffering significant distress and your employer and or the police and or the regulator knew you were suffering distress and then they acted dishonestly and where they acted honestly, it would have ended your distress. The flip side is if they then act dishonestly, then they know that might encourage you. A consequence of somebody in distress where you act dishonestly is that might cause you to attempt suicide. That's what that's the Suicide Act. Any action taken that they know might encourage another to attempt suicide. Now, you don't have to have done it. It's just, it's just that it could have happened. And I've got all the evidence to prove they knew I was a suicide risk. They lied their ass off to me. They absolutely knew that was a potential consequence. Maybe that's what they wanted. I don't know. But now the Met Police are happy that there's a potential crime and they're going to investigate. And that's also, I've got the evidence to show that Lloyd's knew that I was vulnerable, knew that I was distressed, and yet they just carried on their merry way as well. So, but I also want, if you are a whistleblower at the FCA or a bank and you've got evidence to show and know that whistleblowers were suffered detriment, come forward, email Subrol. Like, let's make the case. There's 700 whistleblowers a year suffer detriment, according to studies. So come forward. This is the chance to establish it. And it's not just breaches of Suicide Act, breaches of the Fraud Act. Because let's not forget, if somebody makes a false representation or fails to disclose information or abuses their position with intent to make financial gain for them or cause loss or risk of loss to another, which obviously any lies in a whistleblower process is going to cause or potentially cause loss to the whistleblower, that's fraud, right? And they're now going to agree they've agreed now to investigate it. So everybody, there's the email, make a note of it. There's a crime reference number at the top. Reference that. Let's get as much evidence in as possible and put an end to this once and for all. So, sorry. Anyway, I'm going to start whizzing through now. This is an extract from a fine that the FCA issued against UBS in 2014. Can't remember the exact amount, but I was one of the whistleblowers. I blew the whistle on this conduct for which UBS I think they were fined 400 million or something to that extent. But the banks globally, this was all about collusion in chat rooms and sharing confidential client information. And I think globally, Barclays were fined 2.5 billion by the US regulators in 2015. I think the fines globally were over $10 billion. And it says here, further concerns were raised from UBS by whistleblowers in December 2011, me, February and March 2012, me. So December 11, I'd escalated them up to the heads of FX, and in February, March 2012, I escalated them up to the head of FIC, which is the head of the investment bank, essentially. They buried them. There's a lot more to come on this, and there's going to be some press on this because I've got the evidence to show that the UBS lied to the regulators in the US to secure immunity from prosecution in the US and saved them about $2 billion in fines. So having been destroyed, I lost my job as a result of the disclosures at UBS. So I joined Lloyd's 2012. They're going to be cleaner than clean, right? They're state-owned. They've been through the mill, you know. But between August 12 and September 14, I was forced to make multiple protected disclosures. Now, importantly, and Lindsay's alluded to this before, all of which I did following the whistleblower policy to the letter. And this is the key parts of the whistleblower policy. The whistleblower policy said that it complies with all relevant laws and regulations, and it's to ensure that staff will not suffer any detriment. And it goes on to say colleagues are expected to raise concerns about wrongdoing, and defines that which constitutes wrongdoing: activity that is not compliant with all relevant laws, regulations, internal policies. It does also reference conduct that is not consistent with Lloyd's group values. As I put there, that's a tricky one, because this is the bank that was fined God knows how much for PPI, you know, LIBOR, FX, or you name it, and the HBOS threading forward. So what are those values? Not sure. But this is the line that's most important. And I cannot stress, and I've stressed this so much in blogs and in guidance that I've given whistleblowers. The policy tells employees how to blow the whistle. And all it says on this is colleagues should report a concern about wrongdoing or malpractice to line management in the first instance. That's it. That's one line, but more important and more misleading than you can possibly imagine. And I didn't find that out until the closing arguments of my employment tribunal. So basically, but what it means is that because of what I discovered, no one's got, if you follow the whistleblower policy, you've got zero protection at the employment tribunal. Now, this is an article that was published in 2016 after I won the unfair dismissal, got the maximum compensation. And in it, I raised concerns, you know, how I followed the Lloyd's whistleblower policy. Can everyone still see me?
Forgive me, Paul. We had an accidental infringement on the sharing there. Please just go back to sharing your screen, Paul.
Am I not still sharing it?
No, I think David accidentally started sharing something. David, stop playing with the buttons. And Paul, please go back to what you were sharing just now. Thank you very much indeed. Perfect.
Right. Okay. So, yeah. So basically, and I point out, how can I have been denied whistleblower status when I followed the whistleblower policy to the letter? The way in which they trained us and all 100,000 Lloyd's employees, and it was part of a mandatory training module. So they trained us how to blow the whistle, and essentially Lloyd's argued in closing arguments that I wasn't entitled to any protection at all because I hadn't blown the whistle in the correct way, and that correct way was according to some sort of tribunal case law. So, but tribunal case law that I wasn't aware of, but tribunal case law that trumps all. So, and it's even inconsistent with PIDA to some extent. But you saw on the last page what the whistleblower policy said you should do. Now, a friend of mine, and Lindsay's already mentioned his case before, John Banerjee, was concerned by what he read there when he discovered what had gone on at his employer, RBC, and asked me, what did you mean? What is the inconsistency? So I shared with John my judgment, and I shared with him the case law. Now, the case law says, and it's quite specific, when you make your disclosure, you must allege what law, code, or policy you believe, or you have a reasonable belief is being broken. Even if you're wrong, it doesn't matter. But unless you allege what law or code you believe is being broken, you've got no protection. Did you see that in that line when they told us how? No. So I shared this with John, and then John won his case at the employment tribunal, because now obviously John had to plead secondary that his disclosures were the reason they dismissed him, and he did a fantastic job of that. But unless he'd made his disclosures in the first instance according to that case law with that criteria, he doesn't get a chance to argue the second one. He doesn't get a chance to argue that they were, because you're denied protection, that's it, it ends. Even if the judge was to say, yeah, you know what, they were the reason you were sacked, you wouldn't get protected status because you hadn't included that criteria when you made the disclosures in the first place. And as you can see, John went on to win 1.2 million. I was stuck with my 76 grand. So load of evidence I've now got. I'm not going to go through it all here, but this is a summary. If you want to go back and look it up, there's just failures and dishonesty throughout the FCA, multiple departments from 2015 all the way up to and including January this year, when the FCA lied to me in a in a complaint response. And then they lied to me again after I submitted my letter before action for the judicial review about the GDPR breaches by them, the ICO and the complaint commissioner. They literally lied to me and tried to rewrite history to try and escape accountability via the review. So I've overcome that, I've exposed that, that's all proceeding. So I'll whiz on. Now, Lindsay alluded to a position that the FCA expressed this year. This is an email sent to me in June of this year. And this is where everyone needs to know. The FCA, without telling anybody and behind the scenes, is separating protection from whistleblowing. So they are telling you, yes, you're a whistleblower. Yes, we're treating you as a whistleblower. However, secretly, they're separating protection from that. They say here, it will only be for a court or tribunal to decide whether the disclosures made are qualifying disclosures, i.e. protected disclosures. Now, everybody that comes forward as a whistleblower, you automatically believe, whistleblower, I must be automatically protected. No, they're not, because they're basically saying that the only party that determines whether you're protected or not is a tribunal, which happens 2-4 years after the fact. So when the whistleblower comes forward, the FCA isn't protecting you at all. Right, the FCA has separated protection. Everybody needs to know this. Now, I challenge this extraordinary position. Lindsay's already alluded to certain extraordinary positions that the FCA has come up with this year. But look at this: the FCA go and say all we can do in terms of protection is protect your identity. And once your employer knows your identity, that's it. We can't protect you. Really? So SYSC 18 is the new whistleblower law introduced in 2016 that says it's an offence to cause detriment to a whistleblower. Well, how does the FCA police that? If basically, once your identity is known, according to the FCA, the firm can do whatever they want to you, and the FCA is not going to do anything. It's an extraordinary position. I challenged it on the same day with this email. I copied the Treasury Select Committee on it. I also copied my MP and Ashley Alder, and I explained that's an extraordinary position because it's contrary to PIDA, contrary to the FCA's role as prescribed persons, because PIDA just includes and defines what a prescribed person is. A prescribed person is there to make sure that the whistleblower is protected. That's the whole purpose of PIDA, to make sure people can speak up without fear of detriment. The prescribed person's role is specifically to make sure that the whistleblower is protected. So if you don't want to go to your employer, you can go to the prescribed person, knowing that they will protect you. It's a safer route. So how is the FCA abiding by those obligations under PIDA and adhering to our right? They're not. They have literally separated protection away from whistleblowing. So you're all like lambs to the slaughter if you come forward to them. They still haven't responded to this. 6th of June. So Lindsay got an apology or an admission there was an error. The FCA will never admit to me or that there's an error or they were wrong or apologise. So these are a variety of people that I've raised all these concerns. The FCA protect, they were previously called Public Concern at Work, Treasury Select Committee, Treasury, Lloyds, you name it. So I'm going to play this. Now, this is what you can see here is the disc that the FCA gave me after my whistleblower interview with them on 30th of April 2015. As you see there, it's not marked confidential, right? They gave it to me. And I'm going to play you this section of it. You are going to hear a senior manager at the FCA talking. Right now, listen to this. I haven't ever played one of these before in a slide, so let's hope it works. But right, let me just see.
It is. So that's just to give you an idea of,
can you hear that?
Kind of what we face in day-to-day life. But this information itself is interesting. I'm actually particularly, and I will be relaying this back to my my colleague in retail bank supervision who looks after Lloyds, because the whistleblower issue with Lloyds have been raised several times with them. Actually, I know there is a history of it. There's a history of it from the independence of it from senior management. There's a history of it from the reporting aspect of it, which is clearly what you experienced as well. And I think there's a very wide issue, and certainly it's a focus within this building going forward from here. And we have lots of issues around it and how firms are treating it. But I know specifically that's something that she'll be very interested about this aspect. And that's certainly the kind of things that we will in the future be taking to firms and actually kind of bashing firms around with a big stick to make sure that they do follow procedures correctly, and it doesn't just go to the senior manager, or it doesn't just go to an immediate stop where someone gets to adjudicate on it before it gets to the right level.
It's the most effective way for you to police it.
Absolutely, absolutely.
Pass that responsibility onto people.
Yeah, sure.
Firms, and
well, you put the onus on them to ensure that their whistleblowing processes and procedures are fit for purpose.
Yeah, and I think it is, because without it, I mean, as I say, I mean, people I know at Lloyd's who are now in that catch-22 where they were scared to come forward.
Yeah.
They know,
and that's as a result of clearly that
breach
the system not being fit for purpose. Because if it was, then employees would feel comfortable in going to their whistle team. They've got confidence. They know that they're going to be listened to. It's going to be independent, as Andrew has said. But if they don't have that confidence, then that's a reflection on the state of that particular system.
Now, he clearly says that I was subject to detriment as a whistleblower. And it's a pattern that they're seeing with Lloyd's. And yes, it was a pattern, because they were already aware that Sally Masterson had been subject to the same detriment, and by the same people at Lloyd's. They were also aware of the detriment that Paul Moore, the late, great Paul Moore, HBOS whistleblower, suffered. So they confirm it's a pattern. They confirm I was subject to a detriment. They also confirm that it's a pattern at Lloyd's. The FCA never did anything. They didn't take any action against Lloyd's for it, either for my case or for others. Because let's not forget, they did nothing against Lloyd's for the Sally Marston case. It was only because the likes of Kevin and Anthony Stansfeld stood up for Sally that they apologised to her in November 18 and settled with her, and admitted that they'd lied to her, they'd lied about her. I mean, it's astonishing. And the FCA knew this all along. This is 5 months before my tribunal hearing. Had they done something, then Lloyd's would have had to have settled with me for a substantial sum. But they went out of their way after this to make sure that I could never secure protected whistleblower status. So, and if the FCA's got a problem with that, sue me.
It is.
And that's just a transcript of it, so that if anyone wants to read it later, I'll skip through that. This is just an example how over the years, the FCA then just changed the narrative. This is a summary. Mr. Carley was an FX trader at Lloyd's who accused his employer of making him redundant because he was a whistleblower after he raised concerns about the firm's FX business. Apparently, the firm did not consider him a whistleblower because he was vocal in expressing his reason. For this reason, he is also not considered a whistleblower by the FCA, which Mr. Carley disagrees with. Now, you reconcile that with what the guy said on that call. They had me down as a whistleblower, all ends up. They falsified the narrative over time. So, and this is what they told this journalist and everything. Astonishing stuff. So so I've got over 100 internal FCA emails where they refer to me as a whistleblower over the years, and I'm just going to skip forward though a little bit here. This is the first one, March 2015, right? This is the internal Lloyd's email. The story he relayed sounded like a textbook Peter detriment case, as he has attempted to raise concerns regarding their e-commerce system was eventually made redundant as a consequence. It wasn't just that, it was multiple disclosures that I made. This is the whistleblower team. They confirm at WB, whistleblower debrief, classic Peter detriment case. So, again, I've spoken to the whistleblower to confirm that he's available for that meeting. They classify the Lloyd's, the partial fill, as something that comes under the FX remediation issue, which if it's under the FX remediation program, it must be wrongdoing for which other banks were fined, but Lloyd's were. And there's a whole issue behind that, which will be subject to my tribunal. This is the 9th of July 2015. And I want to bring your attention to the middle part of this. And this is, I'll put it here. I cannot emphasize how stressed this individual is and the effect that this is having on his health and his life. Today, he told me he felt it would have been preferable to have committed suicide before he left Lloyd's rather than make a whistleblowing disclosure and go through this process, because then at least his wife and daughter as well, one daughter, 2 sons, would have received his life insurance money. I firmly believe that he's very close to breaking point because of the way Lloyd's and their lawyers have conducted themselves. They knew where I was, and for the next 2 months prior to my tribunal, they lied their asses off to me. They concealed evidence and just literally hung me out to dry at the employment tribunal. Now, how do you reconcile that with what they did? And this is the prescribed person that's supposed to protect you. Again, just more stuff, but also confirms my MP had written to the FCA begging them, or not begging them, but asking them, please provide an opinion for the benefit of the tribunal. So, you know, not asking for help, just an opinion. And here they're warning the relevant department that they're getting the letter. And this here is an example of the redacted, unlawfully redacted documents. The subject is whistleblower Paul Carlier. The whole bloody document's redacted. It's about me, right? So, and again, this is part of the complaint I made to the ICO. So now I referred earlier to that October 2016 email. And the reason it was being undertaken is I was so distressed. I was, yeah, there was concerns for my well-being. Well, this is dated November 16, and it's from Felicity Johnson of the FCA intelligence team, and she writes to Kenneth MacArthur and Teresa Chambers, the new head of enforcement who's just replaced Mark Stewart, and Jane Atwood. Jane Atwood was a former colleague of the Lloyd's investigator that destroyed Sally Marston and did the same to me and produced that falsified finding. So again, they were vulnerable whistleblower Paul Carlier. She was so concerned with my well-being that she, at the time, she wanted to call the police to come and check on me. Now, this is November 16. They now had a document in their possession by this time, and MacArthur had it, confirming that I was absolutely right. There had been an attempt to default Tesco in 2014, and that but for my actions, they would have got away with it. So they know I'm a suicide risk, and they chose to conceal that from me and then falsify the findings. Now, how do you square that? How you know how distressed I am? You've now got a document dated almost a month earlier that confirms I was right, confirms you dropped the ball in 2015. Do you admit it and say, at least say to me, dear Paul, we are really sorry. We did drop the ball in 2015. We didn't investigate. It's absolutely reprehensible of the bank. We are now going to take action against them and the individuals involved, and we expect the bank to settle with you and make things right with you. That's what they should have done. But instead, despite knowing how distressed I was over this, they chose to conceal it and then lie to me in December 2016. Sorry, right, okay. So, yeah, this is the FCA were backtracking internally. They were trying to deny what was said on that debrief or that recording that I played you earlier. They were trying to literally, and there's another email in this chain where it says, I think Mr. Carlier misinterpreted what was being said. Really? I mean, you've heard the recording. It does what it says on the tin, right? They knew. So now this part, why was I denied whistleblower status at my employment tribunal? It's the case law. So basically, this is the case law I was subject to. And it says that you have to do more than just make a disclosure of information. You have to include specific allegations. That's a law that's being broken and everything else within your reasonable belief. I'm going to skip forward. So that was it. So, but obviously that contradicts the whistleblower policy, and it also contradicts Peter's written. And so I begged the tribunal, you can't subject me or compare me to that case law because the bank trained me to blow the whistle in a certain way. So surely I can only be, my protection is dependent upon how compliant I was with the whistleblower policy. The tribunal rejected it. And again, this is all they said, how to blow the whistle. Colleagues should report a concern about it. That's it. They didn't mention any of the criteria it needed to include. So in March 2016, and I wrote to the FCA and the Treasury Select Committee identifying this inconsistency that deprived me of the protection that I was under the illusion I had, and that essentially deprived everybody in the UK of protection under law. And you can see my summary of the issues here. Now, that was sent to the Treasury Select Committee and the FCA. They did nothing. They did nothing. And when you hear the cases like the recent Lucy Letby case where those babies died and everything else, and everything that's happened since, how much of that could have been prevented if they'd listened? And I said, all that needs to happen is a simple change in the law. The whistleblower policy must reflect the tribunal case law. It is not difficult. But it wasn't until 2017 that I discovered that the Lloyd's whistleblower policy was based on the public concern at work. Now, organisation called Protect, model whistleblower policy. And so I wrote to them, and they're supposed to purport to represent the interests of whistleblowers in the UK. And I wrote to them and said, is this true? And if so, why the hell doesn't it reflect the criteria in the case law? They wrote back and said, we intended it to be deliberately non-legalistic because we don't want to discourage employees from speaking up. So I responded, well, just wrong. You know, this is creating the illusion of protection to employees. I don't want to dwell on this too much because I want to get through the rest of the slides. So, but basically, I had a massive row with them over this issue, right? Their whistleblower policy was leading people like lambs to the slaughter. Why are you not including that criteria in there? So let's fast forward to 2020. And by the way, the CEO of Protect at the time, Public Cinema at the time, Kathy James, promised me she would do a review of my case, right, and see where it fell down, where the flaws in the system. Having promised that they would do it, then failed to. So in 2020, Protect produced the findings of their Silence in the City study, Silence in the City 2 study. It was a study to see what impact the introduction by the FCA in 2016 of new rules, including SYSC 18 that Lindsay mentioned, to protect whistleblowers from detriment had produced for employees. Had it had a positive impact compared to their previous study? Well, and this is the slide. They're all available on their website. So this is a foreword by the CEO of Protect. And she said, we were shocked to find that still 7 in 10 of those raising concerns were victimised for doing so, and a third reported that their concerns were ignored. Why were you shocked? This is exactly what I explained in 2016 and 2017. Why were you shocked? Employers know that no one's got any bloody protection because they're being told to come forward in a way that the employer knows doesn't protect them. So they can do whatever the hell they want. So why are you surprised to find that 7 out of 10 people are still suffering detriment, which is more or less the same as it was from the first study, right? So, and over the period, the FCA hasn't taken one action against any firm for causing detriment to a whistleblower. Yet this number, 7 out of 10, if you think the FCA gets about 1,000 whistleblower reports a year, so if 7 out of 10 are suffering detriment, that's 700 a year. 700 a year are, on average, are suffering detriment. And that's for since 2016 to 2020, right? You don't need to be a mathematician to know, how does that square? All those employees suffering detriment and not one action by the FCA. Why? Because the FCA is separating the protection away from whistleblowing. They're telling you a whistleblower, but they ain't protecting you. And for them to be, this really frustrated me, for them to be shocked. Why? You know, of course, the employer's going to treat you as however they want. And, you know, they go on to turn around and say that this is beggars belief. The FCA will regard as a serious matter any evidence that a firm had hacked to the detriment of a whistleblower. Such evidence could call into question the fitness and propriety of the firm or relevant member staff. Yes, and Lindsay alluded to it before. There's a principle and everything else. And also there's a control function issue here. Right? A firm has to recognise wrongdoing when they see it. That's it. That's not negotiable. If there's wrong, you have to have the ability to recognise it when you see it. That includes this. So you don't need to have all this wordplay over PEDA and what they should and shouldn't do. There's already plenty of rules for them to cover. So, and again, why is the CEO of Protect shocked? This is where they told me they made it deliberately non-legalistic. When a whistleblower needs protection, it's as legalistic as it gets. And the problem is, right, if you haven't made your disclosure in the first instance in the way that's consistent with case law, that's it. You're screwed. You can't go back and change it. That's it. You are done. Because when you need the protection, you're not protected. So again, another email where I raised serious concerns with that issue and their model policy. I'm going to fast forward. So I know I'm probably over time here.
Paul, in fact, let me come in there, Paul. I've got an idea. Okay, I've got an idea. One of the reasons this is to give you a breather. So bear with me a second. Tom, who's speaking later, needs to be off quite shortly. So in a minute, roughly a minute, we'll ask Tom to come and speak for a few minutes. And then we'll get back to you, Paul, which will give you a bit of a break and give you a chance to kind of refocus on where you're at. So please speak for about another minute or so. Then we'll go to Tom and then we'll go back to you. But what you are covering, Mr. Carlier, is absolutely mind-bendingly powerful. The entire whistleblowing system in the UK is flawed because of the exact precise reasons you've set out. And the agencies that ought to be all over this and sorting it out are ignoring what's being said. It's It's shocking, and I'm going to use a very powerful word. It's actually disgusting. It is actually disgusting. Paul, back to you for about a minute, then we'll go to Tom. Thank you.
So I'll skip forward. So this is what they said. Our work is ensuring whistleblowing works means that the law, which is a mechanism for seeking compensation when things have gone wrong, is not the driving force for the messaging in the model policy. I mean, they're saying that protection and the, it's incidental. It's not relevant to what they, the whistleblower policy. And she then goes on patronising me and said, our approach has been developed over a number of years and it's a practical response to a complex problem. No, it ain't. It's simple. Make the policy consistent with the bloody case law. It's not difficult. Nobody's, you don't have to be complex. Andy, you're aware of the simple question we put in the whistleblower document for the call for evidence. It's very simple. All they have to do is say, what law or code do you believe was being breached by the conduct that you witnessed? That's simple. It is that bloody simple. So, and that begs the question of the independence of Protect. And again, another thing where I challenge her to say that law is not and should not be the driving force behind the whistleblower policy, frankly appalling. So, and you can see this is 2017. And again, what is the effect it has on millions of employees. And again, I don't know how many times I could have made, and I was repeatedly raising this with the FCA and also the Treasury Select Committee. Nobody did a thing. So, and I wrote this is the last, in other words, misleading employees into becoming lambs to the slaughter due to the illusion of protection that public concern at work and the firms knew didn't exist if employees followed the policy. So, yeah, I mean, strong words, but it's all been borne out. So having raised the concerns with the FCA, Treasury Select Committee and Protect privately, I then went public and raised the concerns. I didn't, everything was all fact, everything else. And Protect's tagline is speak up, stop harm. Yeah, not unless you speak up about them. And, I was blocked because I raised concerns publicly about their role, their independence and their integrity, all based on facts. You've seen what I've laid out before. So, and it only applies if you're speaking about anyone but them. So I now want to close this bit with answers to my questions that I put to Protect last year at their annual Whistleblower Day event. So I asked, so basically I referred to the in-tribunal case. I was anonymous. I wasn't sure they was going to let me attend if I put my name. So I said that basically the Protect model whistleblower policy in the banks and large firms whistleblower policies, many of which are based on your policy, did not and still do not reflect this criteria. Instead, they simply encourage employees to raise a concern, to raise it internally with the line manager, repeating the question. So explain to me why, right? So this is their answer. The whistleblower policy is really a guide on what a concerned worker should do to raise concerns and the expectations from the internal whistleblower system. This is part of the employer's response to the concerns being raised, and the legal protection of a whistleblower really steps in when things go wrong. The whistleblowing policy is separate at the early stage of a worker raising their concerns. The reason workers don't always know their legal rights is due to low awareness of the law and the struggle to get early legal advice, rather than the whistleblowing policy, which is geared towards encouraging people to raise concerns. They're saying that, you only need the protection when later on, when things go wrong. Well, later on's too late, because if you haven't made the bloody disclosure in the first place, you're not protected when things go wrong. And this is quite clearly, it specifies that all they're interested in is the employer's interests, and Protect is funded largely by the firms that that contribute to their coffers. So that is astonishing. But I do hope that we had a bit of an exchange last year, and Andy's aware of this.
Tell you what, Paul, hold that one there. We'll come back to that point after Tom, because it's a particularly powerful point, and I doubt if most people even believe it. It deserves some time and attention. Ladies and gentlemen, for the moment, can we please put our hands together to thank Paul for a truly outstandingly impactful session, and we'll be back to you, Paul, as soon as Tom finishes his piece. Paul, thank you very much indeed. Absolutely brilliant. Absolutely brilliant. We'll be back to you in literally a few minutes, Paul, okay? And the point you're about to cover, it absolutely nail it on the head, okay? Because it's such an incredible point. I still can't quite get over that conversation we had with that person, Paul. And you know how I reacted rather emotionally to it. I don't mind you referencing that when you speak about it. Paul, we'll be back to you very, very shortly. This is incredible stuff. I'm blown away by what we're hearing tonight. Mr. Tom Devine, please take to the mic, introduce yourself, tell everybody about your wonderful organisation, tell everybody about what you want to share tonight. I know you've got a few minutes. You've got to be away at 2:30 your time in Washington, D.C. So you've got about 5 or 6 minutes or so, sir. Tom, over to you. Thank you very much. Thank you. Please take yourself off mute. Thank you, Tom. Where are you? Where are you?
Thank you very much for honoring me with the invitation to participate. I'm the legal director of the Government Accountability Project since 1979. And during that time, GAP's worked with about 9,000 whistleblowers. And I've worked with about 8,000 of the 9,000. We're a nonprofit, nonpartisan U.S. NGO. We help whistleblowers by defending them against retaliation, everything from informal remedial investigations to a successful Supreme Court appeal. We help them make a difference by investigating their charges and getting solidarity from other witnesses and whistleblowers. We work all the time to get stronger free speech laws, and I've been in the front lines for 38 of them, from Washington, D.C. to the United Nations. And then we share our lessons learned by running a law school clinic. I'm going to leave in a few minutes for Whistleblower Law School Clinic, writing books, survival guides. That's more than enough about GAP. I do want to add a couple of points, just responding to Paul's presentation. One is on this requirement that you have to cite the specific legal citations for the wrongdoing that you're disclosing. That's come up in the United States, and under our Whistleblower Protection Act, that's been rejected, that doctrine. The reasoning is that it's not realistic for an honest witness to have done legal research or be familiar with how to do that, nor do you have to present all of your supporting evidence. You shouldn't have to pull out a file in order to make a lawful whistleblowing disclosure, but you do have to have it available. So if there's follow-up work, you can back up your more generalized discussion. And that might be something to consider for Britain. Also, with respect to protects model law being misleading because it's incomplete, at GAP, Government Accountability Project, we usually have two documents. There's the non-legalistic model policy, or model rights that everybody can understand. And then there's a street law companion piece that translates the nuts and bolts requirements and the details that are necessary for the more generalized model policy. That might be something for Protect to consider. What I wanted to really put a spotlight on today is that we are in the middle of a global legal revolution for freedom of speech where it counts the most, whistleblowing, using free speech rights to challenge abuses of power that betray the public trust. When I first came to GAP in 1979, the US was the only country in the world with a national whistleblower law. We got it in 78. Great Britain was number 2 in 1998. Now we have 48 nations with national whistleblower laws, and with completed implementation of the EU Whistleblower Directive, that'll be 62. This is very much a right and a principle whose time has come. But a lot of the laws that have been passed are false advertising. I almost think of them as traps to identify people who would challenge those who are abusing power and then perfect retaliation against them before they can have real free speech campaigns. They get kind of herded into audiences, agencies with horrible conflicts of interest, and they're basically like plumbers units rather than free speech laws. So GAP teamed up with the International Bar Association a few years ago to evaluate all of the 47 at the time national whistleblower laws, how they compared to 20 best practices that are generally recognized best practices through almost every medium for genuine free speech rights on paper and in reality. And how did Great Britain stand when doing that assessment? Well, the Public Interest Disclosure Act, like a lot of pioneer laws, over time turned into, the pioneer rights turned into reptile rights because they hadn't kept pace with new developments. They'd been heavily attacked and challenged by the power structure effectively. And over time, they were eroded and there were a lot of lessons to be learned. But we're still stuck with the original 1998 rights. They don't cover things like protecting people who assist or associated with whistleblowers. They don't protect those beyond the workplace, like your families or vendors or shareholders or suppliers, as required by the EU Whistleblower Directive. They don't cover the full scope of retaliation, such as civil or criminal liability, threats to property. They don't have adequate protection for confidentiality or identity protection. They don't have a support system or base. They don't have burdens of proof. They don't have disciplinary provisions to prevent retaliation. They don't have credible corrective action, which is the #1 reason whistleblowers remain silent instead of risking retaliation, because it won't make a difference. This law is becoming a global embarrassment. There are some very worthy initiatives on the horizon, though. Whistleblowers UK has proposed an Office of Whistleblower that is very well thought out and could be kind of the foundation for credible rights. But a good foundation with a crummy ramshackle house isn't going to be very effective. The underlying law that the whistleblower office would support is still a disaster. And it's not going to be a very effective office if it's crippled by such a weak law. Protect has come out with a different model from their model law, which is extremely detailed and specific, which they proposed as legislation. It would raise Britain's compliance with 20 best practices from 5 to 15, and move you up from 29th place to tied for 5th place among the world's whistleblower laws. And it would comply with virtually every standard in the EU Whistleblower Directive. So there's a couple of reform initiatives on the horizon that I think it's worth unifying behind because the current rights, I would warn people against filing a case with the current law. Folks, I'm sorry I can't stay, but I've got some students waiting for me. So thank you very much for this invitation.
Thomas, we're going to thank you for your piece, but also welcoming Paul back. Thomas, to hear somebody like yourself with such a massive amount of experience, basically saying the same thing that Paul's saying, which is, blow the whistle at your peril is where we're at right now. And that's a shocking reality to get to. Thomas, thank you very, very much indeed. Thank you for being here.
Thanks for having me, folks.
You're welcome. You're welcome. You're welcome. Thank you. Mr. Paul Carlier, back to you. And folks, if Paul's about to talk about the conversation that occurred a few months ago, please pin back your ears. You're not going to believe this, but I vouch for it. It is absolutely 100% true. Mr. Carlier.
Yep, I'm just going to go back to the sharing my screen. I've only got a little bit more to share on this, but
all good. Thank you, Paul.
So current slide, right? So again, this is from Protect, the whistleblower policy. Now, after there was a whistleblower event last year that Andy ran, and Protect came on, and they put forward their problems. I spoke afterwards, and I didn't hold back. I made my feelings very clear. But again, you've seen today what these are the facts. Like the evidence is there, the emails are there. This is what they were saying, and the inconsistency is undeniable. Now, and Andy said, okay, well, look, because Protect were quite resentful that they didn't get they didn't get a chance to speak after me to try and counter this. So we said, well, okay, let's have an open debate then, publicly, where, back and forth, and they declined. So again, it's like, well, this has to be debated publicly, and it is the major issue. Now, Andy refers to a conversation we had with a whistleblower. Now, this whistleblower came forward this year to the FCA and was concerned about the way the FCA responded and wasn't sure he was getting. So we had a Zoom call, and Andy was on the call, and this person told us that when they went to blow the whistle, the FCA stopped and said, don't specify what law or code you believe is being broken. Leave that to us. The FCA, who I raised this concern with in 2016, literally told that whistleblower, the person who was considering coming forward, to blow the whistle in a way that actively deprived them of protection when they did. I mean, it beggars belief. Now, the FCA, as Lindsay's already pointed out, the FCA they've apologised for certain misstatements. Nonsense. The FCA, I've got evidence to show that when the whistleblower team have responded to me in the past, it wasn't the whistleblower team responding to me. It was actually somebody by the name of Toby Hall in Andrew Bailey's office, a lawyer, another henchman of Bailey's, and that they wrote something to me that said that the FCA didn't have to abide by their own rules about that they impose on banks, that anyone making a reportable concern must be treated as a whistleblower, whether they were an employer or not. That was new rules that were brought in a few years ago. So when I made disclosures about another bank and said these are reportable concerns, the bank's got to treat them as whistleblowers, and so do you. The FCA went, no, we don't. We expect the banks to do that, but we don't have to. We don't have to abide by the same rules. But the FCA in 2023 is actively telling people to blow the whistle in a way that the FCA knows deprives them of protection from the get-go. How do you square that? You've seen, I reported this to the FCA in 2016. I expressly said, this is what's deprived, this is the problem. John recognised it. John blew the whistle, won 1.2 million. 3 other whistleblowers I know that followed my guidance and followed my advice on how to go about it. When they suffered detriment, each of them received between 1.1 and 1.8 million in settlements, because the bank had nowhere to go, because they had the protection in the first place. So what the previous speaker was just saying about the foundation, the foundation is everything. Because if your case is built on quicksand, which mine essentially was without knowing it, and so many others are, you're done. You're going to drown in it. Whereas if you've got the concrete foundations in place, not only are you going to be protected if it goes distance, the chances are it won't go to distance because the bank knows they can't win, or that they've got very less chance of winning. So, and it's not just that. I've helped former female colleagues who suffered sexual discrimination. I mean, it's astonishing, that they were, but again, because they did it in the right way and made us, when they suffered detriment, and seriously, one of my former female colleagues suffered within months of raising concern about her pay, when she discovered that she was, despite being the top earner on her desk, was getting paid less than all the other male people on desk, including less than the junior that was hired to work on her desk. She raised concerns, in 3 months, bang, they're making her redundant, even though she was the biggest earner on the desk. How do you square it? It's clearly a case of sexual discrimination. She came to me, I told her how to make the disclosures, she made the disclosures, and then did a DSAR. And it was the DSAR that basically, holy shit, how do we get out of this? And in the end, they paid her a substantial sum we'll pay it now, but you have to withdraw your DSAR request. She reluctantly agreed because it was a substantial sum. And if you go to tribunal, you could be 4 years before you get anything, if you get anything, and there's no guarantee. So she was put in a position where she really wanted to fight this because it's such a big issue, especially with Me Too and everything else. But they basically made her an offer that she couldn't refuse. And the only reason she got the offer and several years' money was because, she'd done it in the right way. But yet you've got the FCA out there who are literally
Amazing.
blow the whistle in a way that the FCA knows deprives them of protection. So nothing's changed. I think one point I would make, that what protector, and I want to jump forward to this because, the Office of the Whistleblower. Now, this is an initiative by the APPG and Whistleblowing, Whistleblowers UK. Now, I appreciate what, it was Martin, wasn't it, the previous speaker?
Thomas.
I beg your pardon, Thomas. I appreciate what he's saying about what Protect are proposing, but and it would escalate us up. I don't think it would, because look at, if anyone's seen the Wirecard case. Now this was Germany, right? If anyone's seen that documentary, oh my God, right? The EU's no better. So all this about, that they went after the whistleblowers. They literally went after the whistleblowers. Dawn raised the works and threats and everything else. So, the whistleblowing depends on there being an independent function, because even if you change the laws, if the laws are still being, if it's the banks and it's the regulators, they're expected to enforce the laws. We've seen what happens. The laws are already there. No one's enforcing them. And in fact, they're actively circumventing them. So what you need is an independent, free from conflict, free from agenda office of the whistleblower. How that, and that for me is the key, because it doesn't matter how many laws you introduce. It doesn't matter how many, the law is only as good as those that are there to enforce it. And at the moment, everyone who enforces it is entirely conflicted or, in the FCA's case, and I'm saying it now, and it is a strong word, entirely corrupt. So, and they're handcuffed by their own failures and their own incompetence. And unfortunately, unless you have an independent office, nothing's going to change. You can have all the laws you want, but if the people that are there to enforce them aren't enforcing them, what's the point? So I'll leave it there.
Mr. Paul Carlier, I've done this several times over the last few years, this being to thank you for a profoundly thoughtful, insightful, evidence-based commentary from you about such an incredible topic. In all honesty, we could spend the next 10 minutes clapping our hands, and it really, really wouldn't be enough. I know how much time and effort you put into the cause, Paul, not just for your own case and your own interests, but for the wider cause. You are an outstanding human being, Mr. Paul Carlier. And I know that the emotional journey that whistleblowers go on is rather up and rather down. And the downs can be really down and the ups can sometimes be really, really up. Paul, you have nothing but the complete respect of everybody and admiration and thanks of everybody within the Transparency Task Force community. You really, really do. I've been there with you in the police stations when you're trying to get the police to look at the evidence you're trying to give them. And honestly, you're outstanding. Can we please once again thank Mr. Paul Carlier? I'm proud to know you, Paul. Absolutely proud to know you. Thank you very, very much. I think what we might do, Paul, is just send a recording of this to Kevin Hollinrake and say, please share this amongst your team, because there's nothing we can put in writing that's going to be more powerful than what you just said, Paul. There really isn't. You just spoke about the importance of us speaking up and speaking out in the context of whistleblowing. And here's a quotation from Robert F. Kennedy. I've referred to it a few times before. Some of you may be familiar with it because of that. Every time we turn our heads the other way, when we see the law flouted, when we tolerate what we know to be wrong, when we close our eyes and ears to the corrupt, that was the word Paul Carlier used earlier, ladies and gentlemen, corrupt. When we close our eyes and ears to the corrupt because we are too busy or too frightened, when we fail to speak up and speak out, we strike a blow against freedom and decency and justice. Ladies and gentlemen, we're talking about serious stuff here. This is not just about defending people's whistleblowing rights. This is about defending the fundamentals of what our society should be like. This is seriously important stuff that Paul's been talking about. And wait to hear what you're going to hear from Nicholas Wilson in a minute. And after that, we'll go to Q&A. It's about 10 to 8, folks. I'm happy for this conversation just to keep running because this is just so important. Mr. Nicholas Wilson, somebody else who's earned massive respect from the TTF and everybody else in the community. Nicholas, if you're still with us, please unmute and go for it. Thank you.
Thanks, Andy. You said there were ups and downs with whistleblowing. Personally, I've only known the downs. And I earlier on, I in the chat, I put an extract from my diary entry. It's almost exactly 20 years to the day when this all started for me. I had a meeting with HSBC or HFC in their offices in Windsor when they told me, well, I'd acted for the John Lewis Partnership for many years, had a great relationship with them. I did debt recovery for them. Then they sold their accounts business to HFC stroke HSBC stroke HFC.
So I had a meeting with them, and they said you can carry on doing the legal work so long as you do it on the same basis as our existing solicitors. And I said, what was that? And they explained the basis. And I said, that's illegal. You're not allowed to do that. Have you ever been challenged? And they said, we've been reported to the Office of Fair Trading once, but we got away with it. And then they also went on to explain to me how they ripped people off with PPI. They explained the whole scam with PPI. Anyway, so that was that. I went back to the office, said to the firm, you can't do this, it's illegal. I made a big fuss about it. Nothing was being done about it because they were earning millions. In the end, I reported to the Law Society. I was immediately sacked, of course. I went to mediation, knowing I had whistleblower protection, and settled at mediation. Got more than Paul got at his tribunal. I didn't want to go to a tribunal because it would have taken so long, and I needed an income. And I got just under a six-figure sum in settlement of unfair dismissal, nothing to do with whistleblowing. So I had to sign a confidentiality agreement, blah, blah, blah. Now I downsized to Hastings from London, and then I got a consultancy job in a firm in Brighton. And I found out, the Law Society upheld my complaint, but they didn't take any action. Then I found out in Brighton that the firm was still doing it, the thing I'd reported them for. So it was at that stage I went to the FCA, and that's where all my problems started. In fact, as soon as I started going public with this, the whole establishment, the shutters came down with every single British establishment. The FCA, the SFO, the City of London Police, Parliament, the Church of England. I mean, if I'm going to do that talk about HSBC in November, Andy, I'll cover the whole gamut of.
Yes, please, sir. Yes, please, sir. Thank you.
Let me focus on the FCA. So I went to, it was the FSA when I first went to them in 2012, and they did nothing. And eventually I sent them, I did a Freedom of Information Act request, and I said, can you tell me what action you've taken in this matter? And they wrote back and said, we haven't done anything because the bank were entitled to, they were adding illegal charges to debts. And they said the contracts allowed the banks to have these charges. So we haven't taken any action. Well, at the same time, a colleague of mine, Joel Benjamin, and I attended an HSBC AGM, and he challenged Douglas Flint, the CEO of HSBC, the chair, about these illegal charges. And he said, no, he said the contract, no, I beg your pardon. He asked it at the AGM, and then he wrote to HSBC to explain their position. They wrote back and said, the contracts allow the bank to make this. The wording was exactly word for word, punctuation for punctuation, exactly the same as what the FCA sent to me. Exactly the same. So I caught them out, and the only journalist that dealt with this was Ian Fraser, who we all know, but they were colluding. They were colluding and lying under a Freedom of Information Act request. They were lying to me and to Joel, and they were colluding together. Anyway, this took going. The Treasury Select Committee did take this up, and two MPs, George Caravan, Scottish SMP, and a Tory, can't remember his name, Jesse Norman. He took it. I mean, he challenged Wheatley at the time, Martin Wheatley. He said it wasn't true, was it? What you were saying? He said no. So that was that, but still nothing happened. So I then made a complaint to the Complaints Commissioner. Now there was a problem here, because the Complaints Commissioner is Anthony Townsend. Anthony Townsend used to be the CEO of the Solicitors Regulation Authority, who'd taken no action, who'd covered it up originally. So I was complaining about the FCA taking no action to the Complaints Commissioner, who also took no action when he produced a report, and under the maximalisation process sent me the report, and it was another whitewash. And I was obviously maximalisation. I was allowed to go back to him and say, well, if this goes ahead as it's written, I'm going to apply for a judicial review. So he changed it. He changed his report, and in the end, he did a 10-page report, which was excoriating on the FCA. He said it was verging on the farcical. And it was, I mean, it was one of the worst, it was reported in the press at the time, as one of the worst. In fact, he said in his annual end of year report, it was the worst case he'd ever dealt with at the FCA. Their incompetence, their dishonesty, blaming me for various aspects of it. And earlier today, Andy, you tweeted a clip of me talking at the FCA annual general meeting when I challenged Bailey about the fact that, because I had been sent anonymously to this day, I still don't know who sent it, but a huge file of evidence, millions and millions of county court judgments, and I had a computer expert to go through it and extract what I needed, which showed I had evidence of about at least 200,000 cases where this had been going on. And Bailey said to me, he took the piss out of me at this meeting. He said, well, only you know how you got that evidence. And the FCA refused to look at that evidence, even though it was public domain information. It was county court judgments, and they refused to look at it. And also, in the meantime, while all of this was going on, the CEO of HFC Bank committed suicide because he knew he was being investigated. He knew what a massive fraud it was, and he thought he was going to go to prison, and he drowned himself in his own swimming pool. So all that was going on. I kept fighting. Eventually, the FCA made an agreement with the bank, and the bank agreed to pay out, I can't remember, 4 million initially. And then, so I went back to them. And after the FCA report, and the FCA agreed to look at this again. They agreed to re-examine it. Now, bearing in mind, it was to do with John Lewis and HSBC. Immediately, I mean, that was in December, they agreed to re-examine it. In January, they announced 2 new non-executive directors. One was Ruth Kelly from HSBC, who was a sacked MP because she fiddled her expenses. And the other was Baroness Hogg, who from John Lewis Partnership. So they loaded the board of directors with 2 people who were connected to the companies they were investigating. Anyway, cut a long story short, eventually they have agreed, they have paid out 200 million, but it's still nothing near how much it should be. And it's being covered up, and they've drip fed it. You know, they couldn't do it in one announcement because that would have been such a scandal. This was all going on while they were under deferred prosecution agreement in America and so on. It would have been disastrous for this to have been made public. The whole thing's been covered up forever, and it's destroyed my life. I'm now having to sell my house. I can no longer afford to live here. The whole thing is, I mean, it's still ongoing as far as I'm concerned, but I'm trying to move away from it in a sense. You know, I'm 66 now, just started getting my pension. I want to sort of have a quiet life now, but it's been 20 years of hell, and it's still basically covered up. The truth will never be out there, and that's it. I mean, I think that's about 7 minutes. So.
Nicholas, your testimony is about as powerful as it can get. It's virtually impossible to hear you talk about what's happened without thinking there's something absolutely insane with the system.
Corrupt. I have a recording of me at a meeting at the FCA telling Bailey to his face that he is corrupt. I mean, it's quite heated. I had a meeting with them, and I went through all the various things, the LFC or LCF thing. I said, you covered that up there, blah, blah, blah. And I made a list of things, and I said, this organization is totally corrupt. And it's out there on my website. But I mean, that's what we've all heard tonight. We've all discussed that, how corrupt the FCA is, but nobody does it. One final point, I dealt with the City of London Police, and Paul may know about this guy, David Manley. He was the head of fraud, economic crime at City of London Police. Twice he refused to investigate this. He then left City of London Police and then went to work for HSBC. It's all fixed. It's revolving doors. It's jobs for the boys. It's all fixed. It's all totally corrupt. And I won't be moved on that opinion.
I think your views are entirely based on evidence, and please do check out Nicholas's website, folks. I put a link to it earlier in the chat. What another absolutely phenomenal human being. Can we please put our hands together to thank Nicholas and Paul and Lindsay for their talks tonight? It's been as powerful as it can possibly get. It really has been. It's wonderful. We're going to throw things open now for comments and questions from our attendees. I'm so grateful that you're all here. It's 8:05. There's still 18, 19 of you still with us. We're going to go to Lisa first of all. Lisa put a note in the chat to me earlier saying she'd like to say something. Please pin your ears back and listen to what Lisa's going to say. Lisa often speaks from the heart, and I'm hoping you're happy to do so today, Lisa. Lisa, thank you very, very much. Over to you. Thank you.
Thank you, Andy. As you said, this is going to be quite heartbreaking. We all heard from Paul about...
Lisa, forgive me doing it. I'm going to interrupt you, and I've done this before. Are either of the boys at home tonight?
Yes.
You sure?
Yeah. Please
carry on, Lisa. Thank you.
Okay. We've heard from Paul Carlier about his treatment he received as a whistleblower when he was at Lloyds Banking Group and the way was treated. We've heard stories from other whistleblowers of the way the FCA have treated them. Now, neither I or my late husband were whistleblowers. We were victims of, I'll call it a fraud, which I'll come back to. Paul Carlier was kind enough to advise us after we attended a court hearing where a repossession order was granted on our house. Paul helped to uncover some extraordinary things that had taken place. Now, you'd think at that point, he wrote to the FCA and Lloyds Banking Group with detailed information on how they'd destroyed my husband. What they did is they turned on Paul. They tried to blame him for the actions of the FCA and Lloyds Banking Group. The FCA ignored everything he was saying and tried to say that he was only helping us to help himself because he had a personal grudge against the FCA. And he wrote a 17-page document which included the extract from the disc that you've all heard today. And the FCA ignored it all. And they continued to pursue my husband, my late husband, and I for our home. However, we were actually victims of a mortgage redress scheme that was announced on the 27th of July, 2017. That was a day we had our court hearing for our repossession. And as you will all know, that before the FCA issue any redress scheme, there are weeks, if not months, of to-ing and fro-ing between the bank and the FCA. So there was plenty of time for them to halt the repossession of our home. But they didn't. They didn't tell us or the court about the redress scheme. They just continued on and on pursuing us, pursuing Paul. And some of the language that they used is so, when I say they, I mean the FCA, I mean Andrew Bailey's office, I mean the Tony Hall, you've all heard his name, Matt Brewis, you've heard his name probably. All of them wrote disgusting emails where, like I said, they accused Paul of pursuing his own agenda. In March 2018, Paul spoke to ex-colleague of his, And he said to him, are you helping somebody fighting a repossession? And he said, yes. He said, they're going to pin it on you, mate. These are the words. They're going to try and pin it on you that the bank was going to settle with them, but you prevented it. They're going to make you the scapegoat. They want to destroy you. They were going to use my husband and I
If I can,
as collateral damage to destroy Paul. And this is continuing to today, to now. As I said, my husband has since passed away. And I did a DSAR to the FCA in 2021. And all I got after 7 months was 7 pages. There are hundreds of pages, hundreds and hundreds of pages. I have them myself. But when Paul did his at the same time, he received some of my DSAR in his, where they discuss our case and they discuss how they believe that Paul is affecting my husband's health. And it was just awful. I mean, it's just been non-stop. I mean, like I said, we weren't whistleblowers. We were just victims of a mortgage redress scheme. We're just, and they were going to the Andrew Bailey from the 4th of August 2017. I know I'm going backwards and forwards, and I'm sorry about that. He knew from then on that because the FCA were in the offices of Lloyds Banking Group from 2013. They knew what the bank was doing, and Andrew Bailey was prepared to let our home be taken away from us to make a point of destroying Paul Carlier. And that is how low they are. That is how corrupt and how disgusting they are, that they would want to do that. And, you know, I'll just finish on this bit here. You know, a few months ago, my eldest son, he wrote an email to Charlie Nunn. And he said to him, he's 23 now, he said, for half of my life and my younger brother's life, all we knew was our mum and dad fighting Lloyds Banking Group and going to court for repossession orders. That's all we knew. And you knew that my late father was a victim. And you did your utmost to destroy our family. Well, you did. Because my father died.
If I can, Lisa, let me just take it here. I put in the chat the link to this is a mortgage redress scheme that was set up July 2017, and it basically paid out over 283 million to 590,000 customers, all of them who had been subject to fees that had been dishonestly applied, a bit like the way Nick describes the fees that they were just taking. Now, this was agreed in 2017, and it confirms it was 590,000 victims. Now, and it says that consequential damages will be reimbursed as well. But Lloyds were put in charge of it. They literally, it was a smokescreen. It was the FCA protecting Lloyds and limiting liabilities in plain sight. 283 million. It's my position that the actual damage is closer to 2 to 2.5 billion. And the FCA set this up, allowed Lloyds to distribute it. But it says in there, if you look at the link, consequential damages as well as the costs. Now, the consequential damages for this conduct for Peter and Lisa was by the time, you know, because Peter was diagnosed with ME in December 2012. He immediately called the bank, and we've got the call recording now. The bank withheld it. And then when we did get it from their lawyers, TLT, they manipulated the file name to make it look like it was a completely different document and different date. I mean, TLT are scumbags. I mean, they really are. But Peter disclosed his condition, which establishes him as a vulnerable customer on that call. And he says, so I'm looking for your guidance. Now, once you do that, the bank has an obligation to look after you. You've established you're vulnerable, and there are things they have to do. But then we capture the transfer call. So there's a call recording where the guy that Peter's speaking to is now talking to the guy in the other department, and they basically collude, right, just give him a payment holiday. Now, a payment holiday is the biggest trap that there is, because a payment, and basically what it means is that they let you miss 3 payments. But what that does is it creates arrears. Now, they said to Peter, and on this call, and again, this was all concealed. This was not disclosed in the DSAR. I had to identify the missing stuff. Well, where's that? And then we disclosed it later. And this was after the court hearing. So, and the guy then, the call recording with Peter, the guy proposes there's 2 things we can do. We can extend the term, but it's an interest only, so no, or payment holiday. That was a lie, because the other thing they could have done was switch to an alternate product, which would have brought their mortgage payments down from £1,250 to just over £700 a month. And that was available. Now, Peter asked this, but the guy lies. He said there's only 2 things you can do. They'd already premeditated. They wanted the payment holiday, and there's a reason for that. Because as soon as you take the payment holiday, that's arrears. And the guy says to Peter, if you take the payment holiday, when that's up, there's more things we can do. Another lie, because as soon as it was up, you know, there was less things you could do. Because Lloyds, when I raised it with the APPG and I got a response from Lloyds, they said, bank policy, we do not allow customers in arrears to switch mortgage products. They literally trapped him into going into arrears. So now he wasn't entitled to switch mortgage. And if you look at the difference, £500 a month for 5 years, really, by the time, you know, I got involved in everything else, it was equal to roughly the 30 odd grand in arrears that they had now accrued. So if they'd allowed them to switch, they wouldn't have accrued any arrears, because, you know, that £500 a month saved, they would have been able to cope with. But what the bank did in the meantime, they then added all the legal fees. They racked up 140 grand in legal fees, pursuing them for the non-payment and pursuing repossession orders, which they then just added to their account. So you had costs and consequential damages here that they were entitled to under this scheme of over 180,000 by 2018. Bailey's office got involved, and I've got the internal emails now to show that Bailey's office were engineering this false narrative. And that colleague, there's no way that former colleague of mine knew that I was helping somebody with a mortgage case. No way. But his words were, the actual words were, mate, they're going to use this to end you. That was his words. So, and a false narrative was given to the APPG. I alleged, when I found out what was said, that I was basically preventing an agreement. I made a complaint to Bailey's office directly, and they absolutely denied that they'd ever said that to anybody. And yet, years later, I've now got the internal emails that prove that's exactly what they engineered. They engineered a false narrative to say that I was undermining the opportunity for a settlement when there was no intent to settle. They were going for repossession. It was only because of I'd done all I can. I framed this document. I highlighted every issue, everything that they'd done that breached law, code, you name it, the perjury by the lawyers, everything. And Bailey's office went, we don't get involved in individual cases. That was their response. Now, it wasn't until 2020, right? 2 years later. Now, before we get this, I managed to, I shared this story with a victim of HBOS Reading, who had just been paid out some interim funds, and they agreed to fund their lawyers, pay their lawyers to take on Peter and Lisa's case. And the lawyer literally reframed what I had written, added a few legal things to it and everything else, and the lawyers, it was exactly what they There was nothing wrong with my report. It was spot on. As soon as he sent that to Bailey and the bank and the FOSS, Bailey wrote to Lloyd's and desperately tried to get them, like, you got to settle this. And within 2 months, the bank settled and wiped out the 40 grand in arrears by this point and all the legal fees. Just like that. Now, who does that if they're not, they know they're not in the wrong? They absolutely know in the wrong. However, jump forward to, that was December 2018. By that point, Peter had almost 6 years of intolerable stress. Jump forward 2 years to 2020, the FCA then eventually publishes the final notice about this mortgage, the conduct that led to this mortgage redress scheme being set up 3 years earlier. And what they'd done, they'd basically allowed Lloyd's the time to get everyone to accept bullshit offers. They admitted, Lloyd's, that Peter was eligible for this scheme and went, boom, boom, you're entitled to £400. That's what they, under this scheme, that they determined he was entitled to. Whereas we got the full 180 grand wiped out. Now, when they published this final notice, oh my God, it proves that they were on the ground in Lloyd's offices in 2013, the very year Peter was first conned, right? They knew this was going on. They took action and ordered Lloyd's to sort their house out. Lloyd's came back to them in 2014 and went, yeah, we've improved it all and everything else. So the FCA went back in 2015 to check and found nothing had changed. They were still doing all the same shit. Now, you would have thought the FCA would have done something or made it public and done something, and yet 2 years later, it's not until 2 years later, you get this smokescreen of a bullshit redress scheme that pays out a fraction. And then they conceal from people. And unfortunately, Peter and Lisa's lawyer is now retired. But when he found out about the final notice, he was fuming because basically, had they known what was in the final notice, he could have negotiated a huge settlement at that 2018 settlement meeting because of the dishonesty that it proved. So it wouldn't have just been wiping out those costs, because essentially all they did, and don't get me wrong, obviously it was a huge deal getting all that money wiped out. But all that did is it's like allowing a thief to just go and return what they stole from you with no punishment.
Exactly.
The stress that Peter went through, and sadly Peter's passed away, and due to a heart, how much did that 6 years of distress contribute to that? But honestly, I've seen some pond scum kind of conduct over the years, but what they did to Peter and Lisa, and then what they tried to do to me, just is astonishing. But I mean, thankfully that if it wasn't for that lawyer who took it on and eventually just reframed what I'd put, and as soon as it did, but then this is the other thing, the FCA then denied that no, Mr. Bailey didn't intervene, and Lisa did a DSAR to the complaint commissioner, and sure enough, there's the bloody letter that proves that Bailey did write to Horta Osorio. Now, he don't for 1 minute think Bailey wrote to Horta Osorio out of the goodness of his heart, because he wrote in August, it was August or September 2018. This is months after he had tried to bury this and bury me with it, and Peter and Lisa. He was only doing it because now he was shitting himself, pardon the expression, because now they had a lawyer and this could make it into court and the whole shebang would come out. That's why he wanted it settled. So basically, the whole thing is an absolute disgrace. So sorry, I know I've carried on for a bit there.
Well, please don't apologise. And just for the record, yes, we are talking about the gentleman who is currently the governor of the Bank of England. Paul, Lisa, thank you so much. Thank you so much. I really can't think of the right words to express how I feel about what we've heard in the last 20 minutes. Bloody hell. Would anybody else like to come in with any comments or thoughts? Please do. Some of you have been participating very attentively throughout tonight's session. Would anybody else like to come in with any comments before we start bringing the conversation to a close? Kevin, please do come in. Introduce yourself, Kevin, and then share what you'd like to say. Thank you, sir.
Hi, Andy. My name's Kevin Moody. I'm on the chat primarily because I've been involved in a number of mini bond scandals. The mini bond scandals obviously haven't been mentioned tonight. Have been widespread. Obviously, the most famous one was LCF. But if I tell you there's just a plethora about them out there, we obviously mentioned Blackmore bonds. Many of these schemes were conducted by FCA regulated companies, or they had FCA regulated companies acting as security trustees or authenticating documents to say that information was true, all of which, I mean, you could never come across such a big pack of lies, basically, as we know from Blackmore, but I can name many others, property that didn't exist. Now, the FCA constantly denies that these are scams. The FCA constantly says that they were simply high-risk investments. And the cover-up on how these schemes have been operating is an absolute disgrace. And yet all the FCA effectively are now saying is that they're not going to allow people to publicize them or withdraw the promotions, etc. But they're still out there and they're everywhere. This is compounded also by other regulated people, such as accountants, and even when we get to the stage of them inevitably collapsing and going into administration, the administrators seem unwilling to do anything. And as one administrator said to me, there's an awful lot of arse covering that goes on across the board. I'm only raising this because I've constantly tried through the FCA, we've mentioned the commissioner, even with the press, etc., to raise this as a major issue. I mean, because lots and lots of people, I mean, they paid out what 200 million on LCF. There's many of these schemes. There's one that I'm involved in at the moment, HSG, which seems to be about 240 million. There's many others which are about anything from about 4 or 5 million up to 40, 50 million. And still the FCA and the regulatory bodies are just sweeping everything to do with it being systematic fraud, where FCA regulated and other regulated companies are complicit in this fraud under the carpet. I'm just raising this because I think if TTF can help me to raise these issues and get more done about it, I would be remarkably grateful.
Kevin, thank you very much indeed. It's been good to interact with you by email over the last few weeks as well. Kevin, to be honest with you, we are fighting on so many fronts. I think we've got about 14 different projects on the go at the moment, and we're doing what we can on the mini bonds front as well. I assure you we're doing as much as the very limited bandwidth we have is making possible.
I can just come in.
It is indeed, Paul, just a sec. It is truly tragic how many people have been done by mini bonds, and it's truly tragic how poorly the FCA have been regulating the sector. In a moment, we're going to go to final comments from our speakers. Just before we do, and I'll come to you in a moment, Paul, and you can cover this point as well. Just before we do, I want to check in. Does anybody else have anything they want to say before we go to our speakers for final comments? So Nicholas Wilson, to you, sir. Any final comments? Nicholas, you're on mute.
Very briefly, I'll just amplify what I said in the chat. I truly believe Britain is the most corrupt country in the world. Not because you're driving, you're breaking the speed limit and you can give a cop of 50 quid. I don't mean that. It's because of the city, the lawyers, the accountants, the regulators, and not just financial, the Solicitors Regulation Authority. Believe it or not, I believe the Solicitors Regulation Authority are even more corrupt than the FCA. At least HSBC paid out £200 million. The SRA didn't lift a finger to prosecute those solicitors. I think the whole system has been corrupt for hundreds of years, and I honestly don't think it's going to change. And I'm afraid that's it. That's all I have to say.
Nicholas, thank you very much indeed. our very final opportunity, because I'm pretty sure Lindsay's had to go. I'm just going to double check Lindsay's gone. Oh no, Lindsay, you're here. But would you like to just say a few final thoughts, Lindsay, before we go to Paul for his final words? Lindsay, if you can, we'd love you to hear from you again if you can. But if you're otherwise disposed, don't worry.
No, sorry.
Thank you,
No,
Lindsay.
I'm absolutely fine. It's been really interesting listening to everyone's stories this evening. Lisa, my heart absolutely goes out to you. You're an incredibly brave woman. And yes, and I just you know, as I said, I would urge as an organization to, in your response to the whistleblowing thing, just to actually ask, you know, who is watching the watchers? You know, why are they never challenged? You know, but
Lindsay,
that's it from me. Thank you, everyone.
Lindsay, thank you very much indeed. One more thing before I go to Paul. Remember, it's the FCA's annual public meeting tomorrow. All right. Register, attend. If you can't attend at the actual time, and watch the replay. But when you register, ask questions, because my understanding is the FCA like to make a point that they answer everybody's questions. So register and ask questions. The notes in the chat. I'll put it again in a minute while Paul's speaking. Mr. Paul Carlier, I know I'm repeating myself, sir, but you are an absolutely outstanding human being. It's a pleasure and a privilege to know you. The work that you do, constantly battling away, you really are a one-man army, a most remarkable man. Paul Carlier, the final words are yours, sir. Thank you.
Thanks, Andy. I would just like to offer a crumb of comfort, or hopefully a crumb of comfort, to Kevin, that last month lawyers issued letter before action to an FCA authorised firm for 18 million quid on behalf of Blackmore Bond victims. You know, so, and this is the first step in. It's taken a year. You know, I got a load of new evidence after the Panorama program last year, and this has enabled us to do it. But what it proves is it also proves the FCA's efforts to protect this firm, because the FCA had come out in 2020 saying everything was beyond their perimeter authority and powers. And having said that, they kind of then backed themselves into a corner, so they had to keep this illusion up. And they concealed the fact that there were 7 FCA authorised firms involved. And this firm here, the FCA trying to keep their names out of the frame, it was basically done with intent to deprive victims of redress via that, you know, via the mechanism that exists. So this class action, we think, is going to be the first of many. And, you know, it's, you know, the letter before action's gone out. It's the best pleaded case I've seen in years. But it's been the result of a year's worth of work between myself, between victims, and between the lawyers that agreed to take this on. Not ambulance chasers, lawyers with some integrity, and lawyers that are prepared to really do something. And it's for 18 million. But if this is successful, we hope we could roll this out to victims of mini bonds and other scams all over the place. If there's an FCA authorised firm involved, you know, we believe we've now got a way of doing it. So that's just on that point. I'm just going to, if I can, I'm just going to share one document with you that, if I can find it. Yeah, right. Now, this is the Complaint Commissioner. I just want to bring this to your, I don't know if you can see that, can you?
Yeah, we can. Yeah.
Oh, can you still see it?
Yes, we can.
Right. So basically, this is, now, don't forget, Amandeep Samal is going to take over the presidency or the Law Society in January. Right now, this is her lawyer's response to my application for judicial review, because when I got a copy of that smoking gun report that had been concealed from me, I went to her and I said, well, you now have to reopen that case, because I've now got this new evidence that, there you go, it proves that FCA complaint response was dishonest, and it proves that your decision in 2018, or your office decision, was absolutely wrong. Now, her lawyer reiterates her position that as soon as she found out what the smoking gun material was that I had, and I had a copy of it that was non-redacted, she went, basically, it might be, because she'd already confirmed to me that she has to reopen the case if I present new evidence. She refused to reopen it on the basis that, whilst it was new to you, we had a copy of that in 2018, so therefore piss off, we're not going to reopen it. So basically, her position is that if you're a regulator or a body, you're a person in public office like the FCA or the Complaint Commissioner, produce a dishonest response, conceal the evidence, and then when somebody later, for some reason, manages to get that evidence, you can then refuse to reopen it on the basis that, we had it at the time, we were dishonest, but because we had the evidence that proves it was dishonest at the time, we don't have to reopen it. Now, listen to this, right? If that logic is applied to the justice system, all them sub-postmasters that have now had their convictions quashed, the biggest scandal in UK judicial history, like, if her position holds, they would all be deprived of the right to justice because the Post Office had all this evidence that they've now got in their possession at the time they made these false prosecutions. The Post Office had that evidence. So according to Amadit Samal, that would deprive the postmasters of the right to appeal on the basis that they had this new evidence because the Post Office had it in their possession at the time. How is that position anything but corrupt? You're just encouraging a public body, lie your arse off, and then if they do somehow manage to get the evidence to prove you lied your arse off, we can deny it on your behalf because we had it in our possession at the time. Just seriously, I just don't know. Isn't the right to appeal on the basis of new evidence a cornerstone of justice and democracy in the UK? Yeah. And she, if she's going to take that into the Law Society, oh my God, God help us. And I agree with Nick. The UK is. I had every faith in the UK until I availed myself of the system in 2015. I thought everything worked well. I thought that I had rights. I was protected, and there was a mechanism in place to make sure that I and everyone was protected. But it's an illusion, and that's what makes the UK more corrupt than anywhere else. Russia's corrupt. Venezuela. You go there, you're going to have to. It's corrupt. In the UK, there's an illusion of a democracy and a just system. That's what makes it more frightening. That's what makes it more corrupt. So I'll leave it there.
What a remarkable event, folks. What a remarkable event. We're going to be bringing things to a close, but at the same time, we're not. Every event we run has a sense of purpose to it. You know what I said at the beginning. We're going to use the impetus tonight in the notes we sent to Kevin Hollingbrake MP. We'll send him the whole recording of this as well, and we'll urge him and his colleagues to watch it too. We have to keep fighting. If we don't keep fighting, there's just no point. We may as well either completely give up or carry on fighting. And I know what I want to do, and I know what you guys want to do. It's much better to stand up than to stand by. It's much, much better to stand up than stand by. We'll wrap it up there. It's been a very special night tonight, folks. It's been a very, very special night tonight, folks. Wonderful stuff. Thank you all very much indeed. Have a good evening. Bless you all. Cheers. Good night. Good night.